Last week, I'm pleased to say that AILA, along with the American Immigration Council and our law firm, the law firm of Vanderhout in San Francisco and the law firm of Cook and Baxter in Atlanta, filed a class action lawsuit that challenges USCIS's interpretation, narrow interpretation of specialty occupation in the context of market research analysts. We have specifically limited this particular class action to market research analysts, but our hope is that it will expand to other areas in the future. The Occupational Outlook Handbook, which they consider an authoritative source, says that a bachelor's degree is normally or typically required for a market research analyst. But then the USCIS focuses on a different part of the OOH, which says that the job of market research analyst can be accomplished by any variety of undergraduate diplomas. And because of that, it therefore necessarily must not be a specialty occupation. So they're ignoring the language of the OOH that says normally and typically, and focusing on this part that says that various degrees will be accepted, and therefore it's not a specialty degree. Of course, as immigration practitioners and those of us that practice in the field, we know that this doesn't make a lot of sense.
All of those who've been in private practice throughout the last couple of years have seen RFEs go up 70%. Approval rates come down for H-1B visas. We need to solve that, and this lawsuit is directed at doing so. This lawsuit, although limited to market research analysts in the context of H-1B, will hopefully clear a path for all those suffering from the administration's mistreatment of existing law to drive up costs and drive down approval of valid petitions so that talented foreign nationals can join our workforce and help us recover now more than ever from this economic downturn. In a couple months, the judge is going to rule on whether the class of market research analysts that we've put together should be certified. If that is the case, we will move forward from there to a merits decision in approximately 6 to 8 months, depending on the court's calendar. Now, within that, there's a lot of moving parts. We're going to have a national election. We're going to see if the government's going to take us on, or are they going to admit that, yes, they have done an egregious manipulation to the existing law and specifically the criteria for what qualifies as a specialty occupation and their use of the OOH.
There's a number of things that AILA members can be doing right now. The first is, since June 2017, a number of lawsuits have been filed around the country challenging USCIS's interpretation of specialty occupation. AILA members need to be citing these decisions in their responses to RFEs, in their responses to notices of intent to deny, to lay a record that, number one, the district courts are looking at these decisions and they're reviewing these decisions and they're reversing USCIS in a lot of these cases. We need to start establishing a history and a track record of positive district court decisions that are finding that USCIS is just plain wrong. Secondly, AILA members need to be watching out for what happens with this class action, because if the class is certified, then there will be the opportunity to opt in or out of the class, and it will cover nationwide market research analysts and may protect your clients. Third, and most importantly, research and get involved in AILA and the Administrative Litigation Task Force. This task force is set up to educate and train members to go to federal court, because it's one of the tools in our arsenal that we can use to challenge USCI action when it's unlawful or arbitrary. And so look to the ALTF web page. There are sample complaints. There's a list of the members of the task force that can act as mentors for you should you choose to go to federal court. But the goal of the task force is that every AILA member should be able and willing and have the opportunity to go to federal court to challenge these unlawful denials that we're seeing more and more. So we invite you to follow the lawsuit. We're very excited about the endeavor that we've undertaken with AILA and AIC, and we hope that it will be a benefit to all members when we get a positive decision from the court finding that USCIS is just being wrong on these decisions.